Hi, welcome back to Law at Home. We're still in our series on land ownership. And ngayon, we will discuss about the Torrens system. This is our second episode. Last episode, we discussed about the Regalian Doctrine. Okay, and in that episode, we mentioned that the Regalian Doctrine is our basis, to own land in the Philippines. And we inherited this from Spain when we were colonized by Spain. Then, ipinasa itong doktrina na ito to the Americans. And then, when we had our independence, kinikerry pa rin natin ang Regalian Doctrine. Now, ngayon, the Torrens system will answer the question, how do I formalize my ownership of land? Anong proseso ang kailangan kong sundin or gawin to be able to get this evidence, this document, this piece of paper that will really show to the whole world that I own this parcel of land? Diba? So, if our right to own is based on the Regalian Doctrine, the process to formalize that ownership is governed by the Torrens system. So, yun ang relationship ng dalawa. Okay? And talking about this title, this piece of paper, ito yung mga example. Okay? Ito yung original certificate of title, medyo malabo, but this is how it looks like. This is the most common. Pero, meron din akong nakita na in Tagalog, in Filipino, katibayan ng original na titulo. Okay din yan. May mga lugar na in Tagalog, in Filipino. Then, ito is the transfer certificate of title. Okay? We will discuss that. Paano maging transfer certificate of title siya? Pero I think it suggests already, di ba, from the original, pag subsequent dealings niyan, transfer na yan. And it used to look like this. Orange siya ang kulay. Okay? Ngayon, I recently, I was able to transfer title. Ito na ang itsura blue. At saka medyo high-tech na, may mga code, Parang may mga QR code siya. Okay? Of course, the law and even mga documents natin has to be updated. Okay? Has to go through the changing times. Kaya medyo high-tech na rin ang ating mga public document ngayon. So ano ba talaga ang Torrens system? This is our topic now. So again, if our right to own is based on the Regalian Doctrine, the process to formalize this ownership is governed by the Torrens system of land registration. I can give you this analogy para medyo simple tingnan. Ano ba talaga itong Torrens system na ito? For example, ako, I am now of legal age. I won't tell you my age, but I am of legal age na. Nag-asawa na nga ako, Ngayon, I'm a lawyer already. So, I am of legal age. But, do I need a piece of paper to become a person of legal age? Hindi. Because upon reaching the age of 18, which is our age of emancipation in the Philippines, I became a person of legal age. I can enter into contract, I can get married, I can vote, di ba? I don't need a piece of paper. But, if I want to bind somebody else, if I want you and the whole world to acknowledge that I am a person of legal age, yon, kailangan ko na ng document. Kailangan ko na ng piece of paper to show you. Kasi pag sabihin mo, are you really a person of legal age? Can you show it to me? Can you prove it to me? So yun, kailangan na natin ng papel. That's why, being of legal age, kailangan ko na ng birth certificate kasi nandoon nakalagay when I was born and saan, Kailan and saan ako pinanganak. And that will show my age already. And itong birth certificate, may proseso yan, di ba? I-register yan doon sa civil registrar. Meron tayong repository doon sa national office niyan. Lahat ng mga birth nandoon naka-register, naka-record lahat. So parang ganito din ang Torrens system. Okay? Actually, yung title mo, yung ownership mo to a parcel of land, sa batas, no? This is medyo technical ito, but sa batas, kahit wala kang papel you get to have this title, the right to own, okay, parcel of land in the Philippines. Okay? May mga modes of acquiring ownership yan. Itong papel na ito, alam nyo yung function lang nito, is para lang to give notice to the whole world that you own this. And of course, again, evidence of title mo na ito. This is the piece of paper, but actually, you don't need this piece of paper to be able to get and acquire your right. Kasi nga, as I said, sa batas, may mga modes of ownership yan. Modes of acquiring ownership. Ito, resulta na ito, or parang ano na lang ito Parang, yeah, as the term suggests, it is already an evidence of title na pag may mag-question lang, pag may kung gusto mo lang na ma-bound, no? Mapilit mo na lahat ng tao, no? Pugso na nimo ang tanang tao nga mo acknowledge sa imong ownership. That's the important thing about the Torrens title. Okay? So, now we will discuss this today. Now, saan ang galing, no? Where did this system come from? Who invented, who first conceptualized this Torrens system? There was this British customs officer by the name of Robert Torrens. And as he performs his function, nakita niya na how easy and convenient, no, dealing with ships, no, mga barko. No? If you want to buy a ship and you want to have it registered in your name, napakadali because there was a law, the English Merchant Shipping Act. No? May batas na nag-provide ng sistema how to register yung mga transaction involving ships, no? Mga barko. And when this person, Mr. Torrens, was appointed as Registrar of Deeds. So napunta siya sa Registrar of Deeds. Napansin niya, he noticed na itong mga dealings on land, yung mga properties, mga lupa, napakagulo, confusing and uncertain kasi ito, may nag-claim na iba, may nag-claim din na isa, magbagulo, and there was no systematic procedure in registration, unlike in the Shipping Act, no, na may simple and convenient way of registration. Sabi niya, ba't di ko kaya i-adapt yung Shipping Act dito sa lupa? So, as a Registrar of Deeds, nag-imbento siya, inadapt niya yung Shipping Act dito sa mga lupa. Okay? So, ginawa niya yun, and indeed, naging simple, naging mabilis, naging convenient and efficient yung dealings, no, and registration of lands. And this Mr. Torrens, siguro magaling itong taong dito, he was elected or he was appointed as a legislator, naging minister siya, no, sa South Australia. So when he became a national legislator, he authored a bill na doon na niya experience niya as a customs officer and as a registrar of deeds, and yung ginawa niya na simplified and efficient registration procedure, yun ang nilagay niya sa kanyang bill, no? Sa batas na ino-author niya. So, he was successful, no? He was able to pass the law, Real Property Act. And ito na ngayon, it was adopted, nakita din ng ibang bansa, ng ibang mga lugar, that this is a very effective and efficient procedure and system. In-adopt din na iba. So, naging universally accepted siya na process, procedure of registration. Okay? That's why nagiging popular ito, tinatawag na the Torrens system in honor in honor of Robert Torrens. And ito ay napunta din sa Pilipinas. And ito na ang inadapt din natin kasi nga universally accepted siya. In short, no, itong Torrens system na ito, sa pag-aaral namin dito sa land titles and deeds, very simple eh. It's just a matter of, it's a thing of publication. Okay? Ipaalam mo lang sa iba that you own this, no? This is notice, actually. I-discuss ko yan. Parang simply pakinggan. But that's the essence, actually, of the Torrens system. Ipaalam mo sa lahat ng tao sa buong mundo na itong piece of land na ito, itong particular land na ito ay sa akin. Okay? And i-register mo yan kasi itong system na ito of registration, it also gives notice to everyone. Okay? It gives notice to everyone na itong property kay Rico na ito. Okay? Walang ibang claimant niyan. So, in other words, the purpose of the Torrens system, sabi nga sa mga law books natin, no? If you read some law books, if you read the decision of the Supreme Court about the Torrens system, ang purpose ng Torrens system talaga is to quiet the title to land. No? Ano bang quiet? Ba't maingay ba ito? Sabaan din, anong i-quiet man ang title. The idea there is, because before nga magulo, diba? Well, figuratively, it's maingay kasi ang daming nagkiklaim eh. Kasi magulo yung system. With the Torrens system, the purpose is to quiet title. Okay? Maging tahimik na ang iyong ownership because simply yung registration. Okay? Ma-resolve na yung conflict ng mga overlapping claims, yung mga minsan may magandang tanong eh. And I will be discussing this later on, siguro in the next episode. May nagtanong, attorney, paano ba maiwasan yung mga double sale? Nako, dito sa Cebu, in my practice, ang daming double sale. Anong ibig sabihin ng double sale? The same property, kiniklaim lang isa, dalawa, or dalawa, tatlong tao, and they are also presenting deed of sale in their favor. So, yung iba, coming from the same person. Okay? Pero binenta niya sa marami, same lot. Kaya nag-aaway. Okay? So, paano ito maiwasan? Maiwasan ito. And the solution, and the solution is the Torrens system. Okay? Minsan nga lang, itong Torrens system na ito ay naaabuso din. And we will discuss that. Okay? So now, the purpose of the Torrens system is to quiet title, no? Para tahimik na ang iyong ownership. Wala nang gugulo sa'yo. Wala na magsamok-samok nimo sa imong pagpanag-iya o yuta. Okay? Sinabi nga na to put a stop forever any question of the legality of registration. So parang bigyan ka ng security. No? Maging secure ang iyong ownership. That's the importance and the benefit of the Torrens system. Okay? So ngayon, we'll discuss in very quickly lang, na-mention na natin ito in the first episode, yung mga batas na naipasa since Spanish time, hanggang American colonization, hanggang nagkaroon tayo ng independence. Okay? So very quickly lang para makita na yung flow at saka yung history, yung legal history ng Torrens system sa ating bansa. Kasi kahit ngayon, na-mention pa ito eh. Kasi yung iba are also holding still mga old titles. And their ownership is based on the old law. And hindi naman natin masabi na useless na yan or walang bisa na yan. Meron din. Kasi nga, may historical basis yan eh. Okay? So, We mentioned this, that in 1902, American time na ito, there was an act, no? May batas, Act number 496. Ito ang Land Registration Act of 1902. Ito ang first na nag-introduce ng Torrens system sa ating bansa. Okay? Dala-dala ng mga Amerikano. Yung Regalian Doctrine, dala-dala ng mga Espanyol. Ang Torrens system, dala ng mga Amerikano, introduce sa atin through this Land Registration Act of 1902. Anong nakalagay dito? Well, ang proceedings ng registration dito is judicial in nature, no? So, dadaan ka sa korte. Pero voluntary siya. Hindi pinipilit, no? Dili pugson ang tag-iya. Kung mo-register ka, okay. Kung hindi ka mag-register, okay din. So, voluntary siya. But dadaan ka sa court. Judicial process, okay? Now, pagkatapos dyan, there was Act 926. This is the Public Land Act of 1903. Okay? So, more or less the same. May mga, ina-identify doon yung mga iba't ibang modes, okay, of acquiring ownership. No? Mga homestead, mga free patent, and all those things. Ganun pa rin. Judicial process and then voluntary. Now, here comes Act 2259 or the Cadastral Act of 1913. Now, this one makes registration compulsory. Judicial pa rin and then compulsory. Anong nangyari dito sa Cadastral Act? Because of the Cadastral Act, it will now be the government who will initiate. Diba? Kasi yung sa under the Land Registration Act, naghihintay lang ang government kung mag-apply or mag-register yung owner. Dito, parang mas proactive ang government dito. Para the purpose here is para ma-settle din ang lahat ng mga lands of the public domain. Ma-identify siya and then ma-register. Okay, so may cadastral survey na ginagawa ang government. And then, once na nagawa na yung survey, of course may survey plan, ang government ang mag-initiate, it will file a petition in court para marehistro sa government itong mga property na ito. What about yung mga private owners? Anong gagawin nila? So if you are a private owner, nasama yung property mo sa cadastral survey, what you will do is to file your answer or your opposition to the petition of the government. And there, you will prove your right to that particular piece of land. So, mapipilitan ka. Kaya, compulsory na ito. Otherwise, if you will not answer, if you will not file your opposition there, matituluhan yon ng government. Magiging public land yon. That's the Cadastral Act of 1913. Now, panahon ni Manuel L. Quezon, yung Commonwealth Government, merong Commonwealth Act 141 or the Public Land Act of 1936. Okay? Anong significance ng batas na ito? Well, yung mga previous na batas nag-provide ng judicial proceedings. Ito, ng Public Land Act of 1936, Commonwealth Act 141, nag-introduce siya ng administrative process or proceedings also of perfecting your title. Okay? So, yung previous is judicial only, ngayon may administrative modes na, no? Or process of acquiring your title. Kaya dito na, yung mga administrative proceedings na ito, ay yun, sinabi natin na homestead settlement, sale din, no? Sale from the government, okay? Or lease from the government. That's why you are familiar or you've heard. Ngayon, kahit ngayon, meron pa ito eh. Yung miscellaneous sales, leasehold agreement with the government, and then we have what we call free patent. This is most common. If you hear your lolo or lola, if you hear your parents telling you na, anak, meron tayong titulo ha, under free patent ito. Dito na titulo yan under the Commonwealth Act 141 or the Public Land Act of 1936 kasi nag-provide yun ng free patent title. Okay, of course, may mga differences yan sa yung mga judicially decreed na title at saka itong free patent na administrative, no? May mga limitations yan eh. Unlike yung judicially decreed. Pero mamaya, we will discuss that in our next episodes. But ngayon, at least you know that under this law, na-introduce na yung administrative process. So, di ba, regalian doctrine galing sa state. But in so doing, in applying for this title, pwedeng doon sa court, judicial, pwede ding administrative. Okay? Kaya, we go now to the dadaan ka sa DNR, magpa-approve ka sa mga survey mo, tapos doon sa Land Registration Authority. Doon yun manggagaling yung titulo mo na yan. Alright? So, after all those laws, no, of course, naging independent tayo and alam natin, no, sa mga constitution natin, nakasaad yung regalian doctrine. All lands of the public domain belong to the state. And we learn na agricultural land lang ang pwedeng ma-alienated, no? Ma-alienate ng government to private individuals. Okay. In 1978, dahil marami itong mga batas na ito, no? Daghan kayo ni mga balaod nga usahay confusing na gi-codify, no? Gihimuan og usa ka balaod nga nag-codify sa nining tanan nga mga balaod about land registration. And ironically, it was done during the martial law period. And we know that during the martial law period, hindi yun ordinary, may mga batas na dumadaan ng Congress, but alam naman natin na mas powerful yung dictator, yung president eh. So may mga batas na ginawa by mere signature of the president through presidential decrees. Ito. Okay? Nag-codify Presidential Decree 1529 or the so-called Property Registration Decree of 1978 by President Marcos. So, kinocodify lahat. Yung mga registration dito, kung sinong pwedeng mag-apply, paano i-apply, nandito lahat, no? Sa Property Registration Decree, PD 1529. Okay? If you notice, ang title niya is Property Registration Decree. Unlike yung mga previous, okay, Land Registration Act, Public Land Act, so specific sa land. Ito, bakit Property Registration Decree? Just to let you know for now, kasi hindi lang land, okay, ang pwedeng i-register dito, hindi lang about lands. Kahit what we call chattel, no? Yung mga chattel mortgage, meaning kahit yung mga movable property. Okay? For example, sasakyan, okay? Or bahay, ayon, pwedeng ma-register dito. So, hindi lang land ito, mas broad ito. Okay? PD 1529. Pupunta na tayo sa detail. Yung registration na, yung process of registration. Pag nag-discuss tayo ng registration na ngayon ng lupa, okay, I want you to know first that we will be discussing about unregistered land. Anong ibig sabihin ng unregistered land? Meaning, yung mga lupa na hindi pa napapasok sa Torrens system. Meaning, ever since, hindi pa ito na-register. Okay? Kasi pag registered na yan under the Torrens system, iba na yung pag-usapan natin yan, yung mga transfer. Madali lang yan. Ang discussion natin ngayon, yung hindi pa natitulo. Okay? Unregistered land. Paano magkatitulo? Okay? So, yun ang context ng discussion natin dito ngayon. So, PD 1529. Kasi, we're discussing this because sa rural area naman, no? Ang dami kong natanggap na natanggap na mga tawag or I met persons, no, people na kumukonsulta, attorney, merong property yung lolo ko na wala na sila, yung papa ko wala na rin, nandito na sa amin. ang hinahawakan namin ay ano lang, tax declaration. Walang titulo, attorney. So, okay ba ito? Tax declaration lang ang hinahawakan namin. Di ba? Uh, in fact, I have also properties, no? I think I mentioned about, I shared this in some of the fora that I have a farm. But you know, in that part of the province, yung mga lupa talagang wala pang titulo. Hindi pa inabot ng cadastral survey. Kaya, tax declaration lang hinahawakan namin. Pero okay lang yon, no? I-discuss natin yan. Okay. Kaya, yung mga lupa like this, ito yung swak sa topic natin. Paano ka magka-title? Paano mo mapasok sa Torrens system ito para may evidence of title ka na later on we will know anong effect pag nag-Torrens system, pag may Torrens title ka, anong effect nito? Okay? Kaya nga, to quiet title para tahimik na yung ownership. Kasi pag tax declaration lang, baka pwedeng may biglang somebody will just come out and say, oh, this is mine. I have another document. Galing pa ito ng Spanish period or American period. So, parang ganun, you are not secure in your ownership pag wala ka ng title, yung Torrens title na ito. Kaya napaka-importante. So, ngayon, we'll start. Sino ang pwedeng mag-apply ng registration under PD 1529? So, Section 14 of PD 1529, ito yon. Who may file application for registration. So, if you read that law, sinabi dito, merong 4 na classes of individuals na pwedeng mag-file ng application for registration. So, ito ang i-discuss natin ngayon. So, sabi dito, Section 14, who may apply? The following persons may file in the proper court of first instance. So, ngayon pa lang, sabihin ko na sa inyo, itong court of first instance, this is an old term, no? Luma ito. Ngayon, regional trial court na ito. Okay? So, to file in the proper court, an application for registration of title to land, whether personally or through their duly authorized representative. So, number 1, take note ito yung unang pwedeng mag-apply. Those who by themselves or through their predecessors in interest have been in open, continuous, exclusive, and notorious possession and occupation of alienable and disposable lands of the public domain under a bona fide claim of ownership since June 12, 1945 or earlier. So, ato ning tagsa-tagsaon, isa-isahin natin ito. So, yung those who are in open, continuous, exclusive, and notorious possession and occupation. So meaning, nakapossession ka in a particular parcel of land. And the nature of your possession is open, meaning, nakikita sa lahat. Okay? Public siya. Open. Okay? Then, exclusive, continuous. Hindi putol-putol. So, dapat, nag-possess ka ngayon, tuloy-tuloy na siya. Okay? Openly. Lahat nakikita na nandyan ka. Okay? And continuous siya. Then, exclusive. You are possessing the land and you won't allow others to stay in that area. Exclusive siya, to the exclusion of others. Akin ito. So you are claiming your possession and ownership over that particular parcel of land. And then, sabi dito, notorious. Attorney, so kailangan pala akong masama para hindi. What it means, being notorious, is that you really let other people know, na sa iyo yan. Okay? Na sa iyo yan. And dapat malaman ng lahat, na nasa malapit sa iyo na yung property na ay sa iyo na. Okay? Now, anong klaseng property ang pwede dito? Okay? Alienable and disposable land of the public domain. Dapat yung classified lang na pwedeng ma-alienate ng state. So ano ito? under our law ngayon, agricultural land ang pwede. Okay? Kasi nga, di ba, yung tatlong classification na lang ngayon. When we discuss sa Regalian Doctrine, under our Constitution, tatlong classification na ng property, ng land. Agricultural lands. Yung pangalawa, forest or timberland. Pangatlo, national parks. Itong timber or forest, hindi talaga pwedeng ma-alienate yan. Kaya, ang daming kaso, di ba? Na, ito, binenta niya. Actually, timber yan, hindi pwede. Okay? Ito, national parks, hindi mo pwedeng ibenta. Okay? Port San Pedro, hindi mo pwedeng ibenta yan. Okay. Luneta Park, hindi pwedeng ibenta yan. National parks yan eh. Okay? So, agricultural land. So, meaning, dapat itong alienable and disposable lands of the public domain, dapat agricultural ang pinopossess mo. Otherwise, kahit nagpossess ka ng 100 years ng timberland, hindi mo talaga mapagmamayari yan. Okay? Dapat alienable and disposable. Okay. And then, under a bona fide claim. Anong bona fide claim? Good faith. So, dapat wala kang alam na may iba na nag-claim dyan na mas better sa'yo. Okay? Good faith. Meaning, good faith din, it's either na-acquire mo rin yan in good faith. Siguro may deed of sale ka yan. Siguro na-inherit mo yan. Di ba? Or na-acquire mo yan through any of the other modes, no? Siguro from the government. So, yun. If you qualify in this category, pwede ka mag-apply ng registration in your name. Okay. Number 2, Section 14. Those who have acquired ownership of private lands by prescription under the provision of existing laws. Aha. Ano itong prescription na ito? So, if you acquire ownership of private land through prescription, pwede din daw. Now, I will bring you to the civil code. Kasi itong prescription na ito, nasa civil code yan. Okay, so, we are now connecting to another law, civil code. Saan mo makikita ito? Ito, Article 1134 and 1137. So, ito, mga provisions ito about prescription. Just to show you kung paano mo ito ma-acquire din through prescription ang land. Okay? Article 1134 of the Civil Code provides ownership and other real rights over a movable property. By the way, itong immovable property, example nito ay land. Okay? Technical word ito immovable property. But for our discussion, pasok dyan ang land, immovable property. Okay? Acquired, no? Ownership and other real rights over immovable property are acquired by ordinary prescription through possession of 10 years. So, possession pa rin. Parang connected sa number 1, di ba? Open, continuous, exclusive, notorious possession. Pero ito, ordinary prescription, 10 years. Pag nag-possess ka, no, ng land for 10 years, you will acquire it through prescription. Okay. Article 1137. Ownership and other real rights over immovables are also prescribed through uninterrupted adverse possession thereof for 30 years without need of title or of good faith. So, ito tinatawag natin na extraordinary prescription. Yung sa 1134, yun ang ordinary prescription. Kailangan yun ng good faith. Kailangan may basis ka, may title ka na maipakita. When we see title, in a loose term, okay, itong mga modes of acquisition mo, no? Yung how you acquired it, paano mo nakukuha yan, paano ka nag-claim na sa'yo yan. Siguro, again, may deed of sale, may donation, or siguro may inheritance, na-inherit mo sa mga parents mo. So, yon. Ordinary prescription yan, 10 years. Pero pag wala ka noon, meaning wala kang title or kahit hindi ka good faith, no? Alam mo na may nag-claim pero uninterrupted, adverse possession. Nakapossess ka sa property for 30 years, yun, extraordinary prescription, maging sa'yo na ang property na yan. Okay? So, siguro may naalala ka na ngayon, no? Basig na kay na hinumduman na kay amigo or siguro your family may kaso about land and parang narinig mo na they were claiming na sa atin kasi more than 30 years na tayo. Ito yon. Okay? This is one of the modes of acquiring ownership. Extraordinary prescription. So pag pasok ka nito, more than 10 years, more than 30 years, good faith or not good faith, under item number 2 of Section 14 of 1529, pwede ka ring mag-apply. At ito yung basis mo of your right. Okay? Number 3, those who have acquired ownership of private lands or abandoned riverbeds by right of accession or accretion under existing laws. Okay? Ano din ito? Specific ito eh. So meaning, ang land ay malapit sa river, malapit sa ilog. Okay? And by virtue of accession or accretion, this is again technical, no? Hindi natin ma-discuss ito ngayon dito, but the idea is nadagdagan ang lupa mo because of the natural flow of the water and deposits of the soil, okay? Sa current, di ba? So yung nadagdag na lupa na yan, okay? If you are the owner of the land near that riverbank, ikaw din ang magmamay-ari niyan. So if you are applying for that particular portion, you can apply, okay, using this provision in PD 1529. Okay? And just to give you an example, saan din natin makikita itong right na ito, accession, accretion, nasa Civil Code pa rin. Article 457 of the Civil Code provides to the owners of lands adjoining the banks of rivers belong the accretion, which they gradually receive from the effects of the current of the waters. May mga accompanying provisions pa ito. So take note lang sa Article 457. Pwede nyo basahin yan sa Civil Code. And may mga ibang provision dyan, no? Pag na-abandon yung river, ganon, tapos, di ba, nauga, naging tuyo. So, kasi lumipat yung course ng river. So, sinong magmay-ari yung natuyo na part? Yan, very, mga detailed provisions ito ng batas. You can just read it, okay? And then finally, number 4, those who have acquired ownership of land in any other manner provided for by law. So ito, catch-all phrase ito ng PD 1529, Section 14, kung sinong pwedeng mag-apply ng registration. Those who have acquired ownership of land in any other manner provided for by law. So ano itong any other manner provided for by law? Sale, donation, inheritance, or succession. And meron pang iba doon. So, pwede ka dito. Okay? Now, so these are the persons who may file application for registration of title. Okay? And how to do it, that will be our topic for the next episode. Okay? So at least we know now that the Torrens system, okay, is giving us system through these laws. Now, gi-codify sa 1529, nandito yung detailed process. So, nag-start tayo kung sino ang pwedeng mag-apply. And yun ang sinabi natin, no? Itong mga, if you fall under those categories, yun, you have the right to apply for registration of your title. Okay? Next episode, we're going to discuss na the formalities on how to do it, no? Anong petition ang ipa-file, paano i-comply yung mga requirements, saan i-file, and anong process. Okay? So, thank you so much for joining me. This has been Attorney Rico Rintuza. And by the way, don't forget, just send your questions. I have received already the one I mentioned, no? He's actually an engineer, a geodetic engineer. Ang dami niyang experience, no? In survey of lands, and in the process, ang dami niyang na experience and witness na mga problem talaga about land. Kaya sabi niya, attorney, i-discuss mo ito. Double sale, sino daw magmamay-ari ng property malapit sa dagat, no? Sa tabing dagat, sa foreshore, at saka sa tabing ilog. So, yun ang mga questions niya. No? And so very, very useful ito sa discussion natin. I will be answering these questions. I will be discussing that sa subsequent episode natin. Doon sa mga problem areas sa land, doon natin i-discuss lahat na ito. Okay? And even sa procedure, ang daming problema dyan. Okay? Yung default. Now, I don't want to preempt that, our discussion, but I've got a lot of interesting topics more to come. Okay? Kaya, stay tuned. Watch for the next episode. So again, for now, please help me share this knowledge, this information to others, especially your loved ones, your friends. Baga may kilala kayo na may problema sa lupa. Encourage them to send their questions so that we can include it in our discussion. So hopefully, we'll be able to educate them as well. Okay, so you can help me by just share this video as well as our page, and subscribe to our YouTube channel, Rico Rentuza. Okay? So thank you so much. Again, this is Attorney Rico Rentuza reminding you to stay at home, stay safe, and stay out of legal trouble.